Hafa welcome to the Guam Congress Building. The Committee on Health, Land, Justice, and Culture is now called to order. Today's Monday, July 10, and the time is about 1:08 p.m. In compliance with the open government law, notices for this public hearing were published in the Guam Daily Post and posted to the Government of Guam Public Notice Portal on Friday, June 30 and Friday, July 7th, 2023. Notices were also sent by email to all senators and main media broadcasting outlets. This hearing is being live streamed via the Guam Legislature's YouTube channel. All those testifying, please identify yourself for the record before you speak, as this hearing will be transcribed and that will assist us in identifying who's speaking at the time. We have two agenda items for this afternoon's hearing, two bills. Bill number 144-37 LS, sponsored by Therese M. Terlaje, myself, Sabina, Flores, Perez, and Chris Barnett, an act to amend Section 70.20 of Chapter 70 and Section 161.10 and 161.30 and 161.50A and 161.55 and 161.130 of Chapter 161, all of Title 8 Guam Code Annotated, relative to addressing victim confidentiality, reporting, and restitution under the Criminal Injuries Compensation Law. We also have Bill number 132-37 COR, sponsored by Senator William A. Parkinson. It's an act to add a new Section 34.91 to Chapter 34, Title 9 Guam Code Annotated, relative to making destruction of public property during public emergencies a felony. I want to acknowledge my colleagues here today. Senator Tello-Taitukui, Senator Roy Kinata, Senator William Parkinson, and Senator Jesse Lujan. Thank you, colleagues. So we'll begin with the first bill, Bill 144. Again, I will introduce it as the primary sponsor. This bill is an act, again, to add sections to the code, to amend other sections in Title 8, relative to addressing victim confidentiality, reporting, and restitution under the Criminal Injuries Compensation Law. This bill was introduced at the request of the Criminal Injuries Compensation Commission, specifically its chairperson, former judge, former senator, former Attorney General of Guam, Elizabeth Barrett Anderson, and current chair of the commission. And the bill was introduced on June 28 and referred to the Committee on Health, Land, Justice, and Culture on June 30th, 2023. This bill updates the enabling statutes of the Criminal Injuries Compensation Commission in order to address protection of victims' records. It clarifies eligibility criteria, supports the reimbursements to the fund from court-ordered restitution, and maintains confidentiality of records and information of victims of crime as required by local and federal laws and regulations and federal program guidelines, including the Violence Against Women Act, the Family Violence Prevention and Services Act, and the Victims of Crime Act. Furthermore, the Commission determined that vehicular homicide should be added to the list of compensable violent crimes that are covered for compensation. Currently, the statute only allows compensation where the crime charge results from drunk driving. So this legislation seeks to update the compensation or restitution statutes that authorize judges to order a defendant to pay such sums of restitutions to the fund as reimbursement for compensation paid to the victim or eligible person prior to entry of a judge of conviction. The committee requested feedback on the bill from the Criminal Injuries Compensation Commission, of course, the Office of the Attorney General, and the Public Defender Service Corporation, as well as the general public. We've received written testimony in favor of the bill from the Office of the Attorney General and the Honorable Elizabeth Barrett Anderson, Criminal Injuries Compensation Commission Chairperson. Those have been distributed to all the senators. The fiscal note is still pending from the BBMR on this bill. All right. With that, I'd like to invite those who want to present testimony on this bill to please come on. Judge Barrett-Anderson, you may proceed.
Good morning, Madam Chair and Senators of the 37th Guam Legislature. If I could ask that I pass the microphone down to Deputy Attorney General Fred Nishihira first for statements from Attorney General Doug Moylan.
Sure. Attorney Nishihira, Deputy AG.
Thank you. Fred Nishihira, Deputy AG. I'm here testifying on behalf of General Moylan, who could not be able to make it this afternoon. So good afternoon, Senators. Closer? There you go, okay. Hafade, Madam Speaker, as the Attorney General of Guam and the statutory legal advisor for the Criminal Injuries Compensation Commission, I offer this testimony in support of Bill 144-37. The amendments proposed by Bill 144-37 represent the concerted work of the Criminal Injuries Compensation Commission, or CICC, to update its enabling statute and to address victim confidentiality. The draft legislation was approved unanimously by the Commission on April 28, 2023, and I stand in support of the Commission's efforts. The draft legislation amends the definition section for greater clarity and compatibility with other provisions of the chapter. 2, it clarifies the eligibility requirements. 3, adds felony of vehicular homicide and hit and run with injuries. 4, it allows reimbursement directly to the CICC fund from defendant court-ordered restitution. And 5, it prohibits the release of victim confidential information without the prior written consent of the victims. Furthermore, Bill 144-37 improves and expands the CIC's program to benefit more victims of crime, reduces further traumatization of victims, and allows us to be the toughest law enforcers by continuing to hold defendants responsible for their actions. Support of Bill 144-37 is support for the surviving members of vehicular homicide victims who would have otherwise not qualified for assistance for their loved ones' funeral and burial expenses. Support for a defendant being held financially responsible for the injuries they caused, and support for protecting a crime victim from the fear of their private information, medical records, and the sensitive details of their assault could be shared without their consent. The Commission and I seek your earliest passage of this most important legislation. Signed, Douglas Moylan, Attorney General of Guam. Thank you, Madam Speaker.
Thank you very much. Denise Mendiola.
Good afternoon, Madam Speaker and Senators. I just am going to provide oral support to the Bill 144 as a current member of the Commission. I and my fellow Commission members have seen the challenges that our victims have had to face while applying for assistance. I believe that this bill will help us to better serve our victims of crime here on our island. Thank you.
Thank you.
Okay, thank you very much. Senators, I understand that the Speaker has sent down my written testimony. It's one page. I'm not going to read from it. It's almost like reading from a resolution, you know. You've kind of seen it before. So what I want to do, however, is indicate to the Senators that I would like to add an addendum. Senators, do you have an addendum there? Okay, and Madam Speaker, the first on the addendum is just a correction on line 4 of page 9. It started out by saying section 161.55, but the actual content is 161.130. The more important part of my addendum, however, is on page 5, line 18 through 21, if we could turn to that. Do you have a copy of the bill? I think I need a copy of the bill. Okay. This is an addition that I have to tell you, really struggling hard with. And the bill as introduced, Madam Speaker, indicates at line 18, item E, confidential records of crime victims or crime victim or eligible applicants are not subject to disclosure, inspection, publication, broadcasting, production, or reporting to any government or law enforcement entity without prior written consent of the victim or eligible applicant. And I went back to the federal regulation that governs the Crime Victim Act, the Family Violence Act, and the Violence Against Women's Act. And it's there at the bottom, reference only 28 CFR, subpart B, section 91.55. These are state administering agency guidelines. And all the statutes pretty much have the same federal regulation. And if you go down to item 94.115B, it indicates that information about victims can be released under certain circumstances. And it indicates, with the consent of the victim and where compelled by statute or court order. So, Madam Speaker, I'm recommending that E be changed as follows, and I'll read the pertinent addition. I will, without prior written consent of the victim or eligible applicant, except as compelled by statute, court mandate, or allowed by federal regulation. So I think the federal regulations recognize the power of local law legislatures in regard to this information. And we also have to recognize court-ordered mandates, which are subpoenas and orders from court in a particular case, whether it's a civil or a criminal case, where certain information is ordered by the court to be handed over. So I think that that's if the legislature, or I'm sorry, the senators could consider the addendum here to comport more with the way that the federal regulations read. Okay. I'd like to give the senators some background on history. I've been on the commission since summer of 2021. Got my feet wet. And as soon as I started with the commission on its hearings, I recognized that we needed to go back to the enabling legislation. Any good statute, any good piece of legislation that's enacted into law has a genesis. It gets passed, it gets implemented, it gets enforced, and then that's where you see the good parts and maybe the bad parts or the weak parts of the bill. The enabling legislation for the Criminal Injuries Compensation Commission was enacted 30 years ago. I don't even remember the date. But the commission's only been operational since 2016. So really, it's just since 2016 that the commission members and the Attorney General's office has been able to understand how this particular legislation works. Is it working or is it not working? So in the spring of 2022, I sat down with the commission members and our legal counsel, and we were looking at various portions of the statute that needed updating. By November of last year, we came up with the draft piece of legislation that took care of eligible applicants. We knew that there was some need for clarity in eligible applicants and victims. The definitions needed to be polished up. We also needed to have a provision that responded to a decision of the Guam Supreme Court that said unless a statute allows for restitution to be reimbursement to the criminal injuries compensation, the Supreme Court said A trial judge cannot order a defendant who is being sentenced to reimburse the Criminal Injuries Compensation Commission. I said, well, I understand that there's no statute, so what do? You get a statute and you put it in there. So in November we did that. We also, let's see, it was eligibility, definitions, responding to the Supreme Court's decision. Am I missing something, Denise? Anyway, not yet. In November, so we had a good piece of legislation in November. We wanted to get it down to the legislature, but of course, you were a sine die legislature, and it was the end of 36. It was the beginning of a new administration of the Attorney General's office, and so the commission members said, well, let's just sit back and let's wait for the new administration of the Attorney General's office and certainly the 37th Guam legislature to be inaugurated in. So our draft legislation was on the plate. Then in January of this year, we received information from our federal grants office that our hearings, which require social media publication, was contrary to federal regulations. Not just VOCA, but the other two federal statutes. And senators, I can't tell you how embarrassed I was as a commission member not knowing that. I said, oh, I knew that the commission members were very, very uncomfortable when we held at least two, if not three, when we held 2 hearings to adjudicate victims' claims. And of course, it was on social media. We were very careful not to mention victims' names or any specific details, but we were very conscious that victims were being exposed via the social media mandate of open government. But I didn't know we were affronting federal regulations on it. So I wasn't surprised to learn there was federal regulations, but I was kind of disappointed that I didn't know that. So that piece of legislation a bill that we had in November, what a perfect vehicle to tack on additional amendments to address this conflict with federal regulations. So in April of just this year, April 28th, the commission had a hearing, and we went through another draft, and we passed the draft that ultimately was presented to the Speaker and to the legislature and introduced as Bill 144-37. So that's the history of why it may have taken so long, but this bill is not easy. It's a technical bill. It doesn't just go into adding new crimes. That was the one I forgot about. But it goes into confidentiality of victims' records. So it's a product of November. It's a product as added to in April, and now we are here. I am so happy. The commission members are so happy that we have a bill number. I don't know if you, when I hear there's a bill number, it's just like getting a candy. We have a bill number. I don't know if everyone in the public understands what it's like when you get a bill number, but to me it's like getting candy. So the commission is very eager to have this looked at. By the way, senators, we have not had an adjudication on a claim since October of last year. Because of the delay in getting the statute amendment, the commission members are very eager to get back to adjudicating claims as soon as possible. If this could pass this legislature promptly, the commissioners and victims of crime would be very appreciative, and I'd like to get at least 2 more hearings out before the end of the year. So I believe there might be a backlog of victims waiting for the commission to do its work. Senators, thank you very much for listening to my story.
Thank you very much for that great story, Judge Anderson, and for all of your testimony this morning. And I'm especially grateful for the addendum that you're proposing, the amendment, because that was my most uncomfortable provision on this bill. That's the allowing the confidential information to be released if a judge orders it, or, and I can see, I was hoping, yeah, that the lawyers would come in today and make sure that we get that right. So thank you very much for that. And I'm glad we will be consistent with the federal statutes now. That's great. And I want to point out to my colleagues, and those listening, one part of the bill adds another crime to the list of crimes that are currently compensable under the statute. So there are a list of 26 violent crimes. Those are the ones that are covered. And we are adding 2 to that list, and that should have been underlined, numbers 27 and 28 on page 8 of the bill. So we're adding hit and run with injuries, failure to stop felony, and vehicular homicide. Currently only the drunk driving while impaired is covered as a compensable.
And Senators, if I could mention number 27 there, we actually have had claims filed by 2 or 3 victims whose loved ones have either been severely injured or have died, but that particular crime was not part of the list, and at that time we had to deny the claim. So adding that, I think, would be very, very beneficial to victims of crime.
Thank you. And I'm remiss in recognizing my other colleagues who've joined us, Senator Chris Barnett and Senator Joanne Brown, the Vice Chair of our committee. Yeah, thank you, Senators, for joining us. All right, so I'm going to open this for questioning. Senator Taitigui. Deputy AG Zona, did you want to testify on this bill? Okay, all right, thank you. Senator Taitigui.
Thank you, Madam Speaker, Madam Chair. Good afternoon, Senator. Good to see you, and Denise, and of course, Attorney General's office. I'm glad you're here. I had some questions, but it was answered in your testimony that you provided. My only concern here is, I do understand the importance of this legislation and what you're trying to accomplish here, the confidentiality of a victim. But my only concern is how can you ensure that the transparency part, or that nobody is actually fraudulently making a claim that these certain information is not being able to be provided out there. I'm just worried about, not having that critical information, down the line, especially if you have, for instance, a claim that was made and everything is like closed. Nobody can open it or look into it. Would that hinder the process of any kind of prosecution to the defendant or who is accused of causing any kind of harm or damage to the victim? Do you see any issues with withholding information that might deter, or, delay any kind of closure?
Or do you want? She could actually answer it. There are probably 2 or 3 people that could answer this, but I'll venture, and then if Deputy Attorney General or Chief Prosecutor, right? And the Chief Prosecutor might also be able to chime in. Are you concerned, Senator? I need clarification on your question. Are you concerned whether keeping the information confidential without the victim's consent, whether it would hinder successful prosecution? Is that your concern?
Or because of lack of transparency, the misuse or false claims? How do you look into that?
Okay, so there's a 2-part. Let me get to the issue of misuse and false claims. Before a claim is presented to the commission, we are a commission of 4. The staff of the Office of the Attorney General reviews the application, which is very thorough. In order to apply, you have to have a police report. So a large part of the basis of whether the crime that you are applying for fits the 27 categories is what's on the police report, what's in the investigative report from the police department. And those records are not confidential, those are public records.
Okay.
What the commission has been most concerned with is not whether the victim is applying under a false crime or a made-up crime, because we have the police report. It's whether the victim's claim for damages, such as personal injury. Funeral expenses is pretty clear. You know, we get those. Medical expenses, hospital expenses, etc. Whether those are validly justified. And we do require the applicant and victim to produce billings from Guam Memorial Hospital, GRMC Hospital, from other psychologists, psychiatrists, counselors. So they have to come in with a receipt. The statute does not compensate just because the victim says. It has to be an expense incurred. And the only way you can justify it's an expense incurred is if you have the billings and justification for those claims. And I can guarantee you that the 4 commissioners are very careful in looking at the claims to make sure that they are based on proven billings and other documentation that justifies every dollar that we pay out.
Is that, I guess, a standard procedure that you go down? Is this list actually in a format of some way, like psychiatrists, it requires 2 doctors to review the injured person, one, you know, anything like that? Do you have actually the guidelines to say whether it needs 1 psychiatrist to look at the individual, or does it require 2 doctors' opinions, 1 doctor's opinion?
It's not a quantity, like you have 2 doctors because someone had their leg broken. If a victim had their leg broken as a result of an aggravated assault, is there records at a hospital or a doctor's office that proves that the victim was treated for that type of injury?
Okay.
I don't have, and I don't think any of the commission members have any reason to believe that the records of a doctor's office are falsified. By the way, we have a doctor, Dr. Lisa Flores, and we actually, when I personally like to see when she looks at the receipts of the billings, she knows exactly what they are. And it's very good because oftentimes Dr. Flores, as a member of the commission, will ask the victim certain medical questions. And so I'm so glad that we do have a doctor on the commission. So I don't know if that helps answer or assures Senator that the commission is looking very carefully at the applications and making sure that they are justified and that they should be paid.
But thank you so much for that. You know, I totally support anything that can support those victims, you know, of crime, that what we can avail them to. I mean, they've already endured absolutely hardship, you know, in the first place, and it's it's emotional and taxing, especially when you're going through something like that. So, you know, I do support this bill, and I appreciate looking into it. Is this, you know, isn't this the same bill that you were working with Senator Duenas and another Senator Duenas and another senator on? Was this the same particular bill?
It was the same week, just 48 hours apart. I had met with Senator Fisher and Senator Duenas, and then the speaker also asked me to come down within the same week to go over the bill with her. So it was sort of as many senators as you can get supporting the bill.
Yeah,
is a good thing.
I remember hearing something about this, and I just wanted to
It
make
is,
sure.
yes.
This is that bill that you're talking about. So
Im-
you don't have another bill that's
No,
on
no.
the agenda coming up?
It's
Okay.
improved because my meeting with the senator, I thought she had some very, very good recommendations for additions to the bill. And so we incorporated her changes when I had a meeting with her. I was very, very, very pleased with my meeting with the
Okay.
speaker.
Well, thank you so much, and I'm glad Senator Fisher and Senator Duenas also came to your attention first on this. Appreciate it.
Thank you.
Thank you, Senator Teitzagui. Senator Kanata.
I just want to thank the panel, Attorney General Barrett-Anderson. Thank you for your counsel, and to the council members as well, Ms. Mendiola. Thank you for coming today. I think this bill has some valid points that we will need to address in the legislative process, so we'll look forward to seeing it on session floor, I'm sure. Thank you again. You guys have a great day. God bless.
Thank you, Senator. Senator Parkinson?
Thank you for your service, and I have no questions, Madam Chair.
Thank you. Senator Lujan.
Thank you, Madam Chair. Thank you, panel, for being here. Judge, I'm sorry I wasn't at the office that day that you came. I was supposed to be there, but I was out. But I was briefed by actually Senators Duenas and Fisher regarding the meeting. So actually, the bill's a no-brainer, and so I'm full support. But let me ask you something, and I don't know who can answer this. It has nothing to do with the victim, but this is something that I got a call on about a month ago regarding compensation. And the guilty party had just been released from prison. Was there for, I think, 25 to 30 years, I think, and is required to, I guess, a compensation, right? Required to get work and, I guess, paid to the victim.
Restitution, that's
Restitution.
not restitution.
Yes, restitution. Yes, restitution. The problem with that, and he sought my office, and family members sought my office, because I think it's the parole entity of the courts had given him a letter of some sort with his
promissory note?
No, a letter of some sort to get an ID.
Oh, I see.
He was incarcerated for close to 30 years. So all his IDs had expired and things like
Yes.
that, right? He was born in a foreign country, but has become a U.S. citizen. So all that paperwork within typhoons and all that are gone. He has very little family members who don't know locations of any documents. And he's required to pay restitution, but required to get a job. What was given to him to take to Rev and Tax to get a form of ID was not honored and could not be honored. So he sought our office to try to see what we can do to be able to help him get some sort of ID, because everyone required him to have an ID before they moved on. He needed an ID to get reissued a Social Security card, needed an ID to get a driver's license, but he previously had all this. It's just expired and all that. So I'm just wondering, I'm sure this is probably not the only case, but I just had that call about a month ago, and I don't know if that was ever resolved, because we had asked him to made an appointment with him with the director of Rev and Tax to see what they can do, because he's required by the courts to pay restitution. And so I don't know at this point, again, it's nothing to do with this, but it has to do with this because of the restitution that needs to be paid in, and how can we...
Well, it has to do also with the role of the Attorney General, who is obligated to collect restitution for the victims of crime when defendants leave prison system. In fact, that's a program that Deputy Attorney General Fred Nishihira has instituted. So we collect for the victim on the restitution when defendants get out. I am very, very aware, because as in my tenure as a judge, that when defendants who are incarcerated for a length of time get out, it's very hard for them to get a job. And it's not only that they don't have an ID anymore, it's
Sure.
they have a felony record.
No, absolutely.
So even if
absolutely.
they have
So
an ID, they may not have to
yeah,
get a job because
it's
of their
a
record.
double whammy, yes, of course.
Double whammy. I believe, my understanding is that the probation office or the parole office does have a mechanism or tries to assist, and I think that's what you're saying. I'm not aware of what document the parole board is recommending to defendants to go to rev and tax on, but that should be resolved. It's been decades-old issues. I'm very, as you were asking the question, I thought, well, maybe there's been some future, because I've been gone from the bench since 10 years. To hear that a defendant, I'm not a defendant, but an inmate who is released comes before you because they can't get an ID.
About a month and a half ago, yeah.
Did Rev and Tax indicate why, the basis for their rejection of a document?
No, they didn't indicate. They said he needed an ID and he had to go somewhere else to seek an ID. He says, well, I need to start with you because everybody else, he went to Social Security and to renew, because he doesn't even know his Social Security number, and he needed an ID to be able to get that. So he needed to go there to start off to get a GovGuam ID to be able to get all the other things that he needed. He couldn't get his birth certificate here because he wasn't born here, but he's a U.S. citizen and all those records as well. He needed an ID to show.
Very common problem with inmates who are released, absolutely. I'm sorry, I'm not in that side of the system anymore.
Yeah.
Fred?
Yes, thank you, Senator. So, like Judd said, we do the restitution. Our office does the restitution. And of course, the number one problem we had was collecting from criminals. And they couldn't get jobs because they didn't have ID exactly for the reason you said. So there, we created a memorandum of understanding, and that was with Public Health and the Department of Revenue and Taxation with the Department of Corrections. So the way it works, they have to be U.S. citizens at least, because we didn't have access to foreign countries' information. But if they were a U.S. citizen, especially if they had a Guam ID or license, they could take their DOC number and information, they go to the Department of Public Health, and they get the information that they needed from Public Health and take it forward to DRT. So there is an existing memorandum of understanding. If that person that called you, if you want them to send them to the second floor, Bernie Alvarez, she runs basically the restitution. She'll be able to pull out the memorandum of understanding. It's probably about 3 years old to address that specific problem. It won't be able to get them Social Security, but at least their local Guam ID that'll enable them to obtain work.
Because he became a U.S. citizen when he came here to Guam, but he doesn't have. And again, I guess the family members he was living with are no longer around, and so none of his paperwork is anywhere, and so he doesn't have anything to say who he is, basically. And so, he was starting from ground zero, basically.
Senator, I think that information also needs to be given to DRT so that Daphne can have that spread down to, the average, the person on the window. Because those young clerks, they may not know about this. And if it's just 3 years old, it needs to sort of get into the system, and maybe it's just not there
And that's
yet.
what we did. We spoke to one person and referred us, I think, 3 or 4 times. And finally, we spoke to Daphne, and we got an appointment for him to go see her, explain, the situation, and bring the paperwork that he was given by the courts, to be able to get his identification. But you said Bernie Alvarez? Bernie Alvarez. Okay.
Yes.
And I'll get a hold of you, and maybe we'll get that, that memo of understanding, so we can have it, so we can know how to answer that question when it arises again. Okay? Well, thank you very much. But I'm in full support of the bill. Thank you very much.
Thank you, Senator Lujan. Senator Brown.
Thank you, Madam Speaker. I really don't have any questions. I think the presentation is pretty straightforward in understanding the need to keep this particular information private And of course, all the other actions of the commission will be open to the public, so I have no issue with that. Thank you for coming and providing your testimony. Thank you.
Thank you, Senator Brown. Senator Barnett.
Thank you, Madam Speaker. Also have no further comments. Just glad that we're able to get this bill heard and that you recognize the urgency of moving this measure along in an expedited manner. And also want to thank Your Honor for that good catch with the addendum and saving us the trouble in the markup. So thank you.
Well,
Thank you so much.
both the speaker and I were sort of tormenting about that.
I'm
and I
just
said
happy my name's on this bill. You guys, I consider you two a couple of the greatest legal minds that this island has seen. So I'm just happy to be here. Thank you.
Okay,
Madam,
thank you.
Senator, I'm glad I caught it for the speaker as well. Okay.
Thank you. I just want to have you point out, if you can, because you did this at another hearing we had, and I thought the public should be very aware of this, because I was not even aware of that at the time. So one of the benefits of this whole Criminal Injury Compensation Commission, or the setup, is that we're going to compensate victims, and this compensation might come even before there's a trial, so they get this compensation as fast as you guys can adjudicate it. But there was that other section of the law that you pointed out that they are entitled under our Guam law to compensation whether or not any person is prosecuted for or convicted of a crime arising out of that act or omission.
Right, right. Yeah, Senator, Madam Speaker, the only limitations are the various crimes. There's going to be 29 now. 18-month statute of limitations. You don't even have to have an arrest. In a hit and run, oftentimes you don't find the perpetrator who hit this person, killed the person, and it's never solved. But it doesn't mean the victim hasn't suffered harm. And the compensation is so limited. It's only $10,000 for miscellaneous and $20,000 for injuries. And oftentimes the medical goes directly to Guam Memorial Hospital or GRMC. It doesn't go into the pocket of the victim, and those bills are a lot higher. So it is not reliant on a conviction. It's not reliant on an arrest. It's police report, file within 18 months under these. It has to be a violent type crime. Okay.
All right, well, thank you again. There being no further testimony, I want to thank the members of the commission for their diligent work. Of course, the Attorney General's office, who really helps to manage this program for the commission and has really, Attorney Nishihira in particular and the judge together in their term had really boosted this commission's activity and victims' compensation. So thank you very much for the continued work and to Attorney General's continued work in this regard as well. Si Diyos masi. So I will consider this bill 144-37 duly heard. It is 2:50 p.m. We'll now move on to the next item on our agenda, which is bill number 132-37 COR, sponsored by Senator William A. Parkinson, and I will let him introduce the bill.
Thank you, Madam Speaker. Bill number 132-37 COR, an act to add a new subsection 34.91 to Chapter 34, Title 9, Guam Code Annotated, relative to making destruction of public property during public emergencies a felony. Bill 132-37 would make it a felony if someone vandalizes public property during times of public emergency. This bill was introduced after I received news that GWA's water well facilities were vandalized shortly after Typhoon Mawar passed through Guam. I then spoke with John Beneventi, General Manager of GPA, who said that a total of 5 water tanks were damaged due to vandalization. These were essential tanks that were providing people with potable water after the typhoon, when many people still did not have access to running water. I want to be clear, behavior like this during times when our island is recovering from great disaster is criminal behavior. After disasters like Typhoon Mawar, we need to be protecting critical infrastructure to ensure speedy recovery. And anyone who gets in the way of that should be punished accordingly. When our island is in a state of emergency, we need to be all hands on deck. We need to be helping our essential workers restore services like power and water as soon as possible. Destroying crucial infrastructure when our island is most in need of basic utilities negatively affects every single resident and makes our essential workers waste precious time fixing something that they don't need to be fixing. We, as an island, should not stand for that kind of behavior. And with that, I look forward to the discussion on the bill today and look forward to its passing. Thank you, Madam Speaker.
Thank you, Senator Parkinson. I want to note that we received written testimony on this bill from Esther J.C. Agagi, Homeland Security Advisor, Office of Guam Homeland Security, and from the Office of the Attorney General of Guam. The fiscal note we also received, and it says that the reference bill does not ascertain any immediate fiscal impact upon the revenues or expenditures of any funds from the government of Guam. And with that, I'd like to invite testimony from our Chief Prosecutor. Please identify yourself for the record.
Thank you. Good afternoon, Madam Speaker and Senators. I'm Heather Zona. I'm the Acting Chief Prosecutor from the Office of the Attorney General. So on behalf of Attorney General Douglas Moylan, thank you for the opportunity to comment on this bill. The proposed bill would make it a felony for anyone to destroy property belonging to the government of Guam during times of public emergencies. The Office of the Attorney General supports imposing criminal penalties on those who destroy government property, particularly in times of public emergencies. The island is still recovering from Typhoon Mawar, which left our island without power or water for an extended period of time. The island is still recovering from the devastation of the typhoon. During public emergencies, the island is called upon to band together and to respond in order to preserve human life. This is our highest priority. So law enforcement and first responders are stretched particularly thin during these times. They take their duties seriously, but we cannot ignore that the tasks they are assigned to do are substantial. Government property is property that benefits the entire community, whether it is a police or fire department vehicle that responds to those in distress, medical supplies, electrical wires, structures in a park designed for the community's enjoyment, or even historical monuments dedicated to commemorate Guam's unique history. Destruction of government property during times of crisis is particularly despicable because that destruction harms our community. The public is denied the benefit of those items, and law enforcement is required to devote resources to address those crimes. We do believe the bill as presently drafted should include some additional points, however. First, we believe the bill should make clear that the destruction of government property should not be limited to the actual time of emergency. I believe currently it's phrased times of public emergencies, which is somewhat ambiguous. We think that it should extend for 90 days after the declared end of the emergency. As drafted, the bill would appear to be limited to the actual emergency. And while criminals can destroy property during the actual typhoon, for example, it would appear that a majority of crimes often occur when criminals take advantage of circumstances created during times of emergencies. For example, a security gate or door blown off during a typhoon allows criminals the opportunity to destroy property within a facility. Second, we believe the bill should be more robust by including government property that is misused, misappropriated, or even stolen during declared emergencies, and again, for 90 days after the end of the emergency. The Office of the Attorney General is particularly concerned that what otherwise would be misuse or misappropriation of government property would somehow go unpunished during emergencies. And finally, we would encourage the legislature to consider drafting a bill to add additional penalties for any crimes committed during declared emergencies and for 90 days following the end of the emergency. Again, law enforcement and first responders are tasked with responding to a very heavy workload during and following emergencies. Diverting law enforcement to address crimes committed during emergencies harms our island even more than it would otherwise, precisely because of the nature of times of crisis. It also disrupts the island's ability to fully recover from such times. Stealing government property during emergencies and during the recovery period immediately afterwards threatens our community's health and safety, such as in the case of electrical wire that is stolen, which otherwise would restore electricity to a village. During Mawar, we heard many stories of people who were struggling to keep their insulin and other medications refrigerated. Denying these citizens electricity, which they would have, but for the theft of electrical wire, for example, is reprehensible, and it should have a special penalty. So on behalf of Attorney General Douglas Moylan and myself, I thank you for the opportunity to provide testimony on this very important issue. Thank you.
Thank you very much, Acting Chief Prosecutor, Deputy Attorney General. All right, I'll defer to the sponsor if there's any questions or comments to begin.
Thank you, ma'am, for your testimony today. I have no questions. Your points are duly noted. Thank you.
Thank you. Thank you, Senator.
Thank you, Senator. I'd just like to ask, so your testimony makes 3 recommendations. One is to extend it for a period up to 90 days after the emergency, and I can see that. I'm just curious, we're still under emergency condition, is that correct? Is that your understanding?
My understanding is that actually the emergency was ended, that we're not in the condition of readiness, et cetera. Our recommendation is for first of all, that the time period be very specific, because for my job to prosecute crimes, I need to always be able to fit the crime within the statute. So if the statute is ambiguous as to when it actually kicks in, the tie goes to the defendant. It doesn't go to my office. It doesn't go to the prosecution. So for us, in order to know whether something is legitimately going to be covered by a particular law, we need to have that time period very, very clearly set forth. The second is that we would actually like for the emergency, the time period to extend beyond when the emergency is declared over. Because we all know that as a result of an emergency can happen and we can no longer be in a state of emergency, but that doesn't mean that we're not still recovering. So there are going to still always be buildings that need to be retrofitted. There are going to be roads that are going to need to be fixed. Maybe even areas of the island that need more, maybe they were fixed in order to be operable, but they're going to need some long-term repair. So for that reason, we'd like to continue that time period for about 90 days following the declared end of the emergency.
All right. No, I completely understand the rationale for extending it. I wanted to clarify this term, end of the emergency. So, for example, right now, has the emergency ended or not? And you made reference to the condition of readiness. So you're saying it ended when we were in condition 1?
I actually think the governor decides when the state of emergency is over under our law. So even in COVID, for example, COVID's probably a better
right, we were under executive orders. She used executive orders to determine the emergency and when it would end.
Right.
They had expiration dates.
That's correct.
So
because otherwise it has to be tied to the emergency.
Yes.
Otherwise it's very confusing, I think, for everyone.
What about things like when the executive orders say we're in the state of emergency for water? Remember, we were in the state of emergency for water. I've got to go review if we were still under state of emergency for everything else, but there was a special EO, executive order, for water that says so don't use any water on all these other issues. If we had a state of emergency for something in particular like that, or a state of emergency for CPS, we've seen that executive order, with that, how would you interpret if this statute was in place at that time?
Well, I think that it's really up to the legislature to kind of determine that. So the legislature has within its power, obviously, to say, to be very clear in terms of what the emergency is. There could be agencies, particular agencies that are themselves in the state of an emergency due to hiring conditions, or maybe everyone at the agency has gotten sick, or their building is condemned, or who knows. But that is precisely why the legislation needs to be a little bit more specific. So the legislature has within its power, I suppose, to say, well, if there's just a state of emergency regarding water, any crimes that are committed during a declared state of emergency as properly declared by the governor fit within this statute, or not. I mean, but it needs to be very specific.
All right, yeah, I agree.
Yeah.
And so I agree with the bill's intent to increase penalties for misconduct during emergencies that is really threatening additional lives, that not necessary. But so we're talking now about making it a felony, though. So that's increased penalties is one thing, but making these crimes a felony is another. And I just want to go over the crimes that would then become felonies, and I want to. It says maliciously tearing down, damaging, mutilating, or destroying property of the government. I don't know, I'm thinking, mutilating property of the government might be, I mean, there's a scale of that, right? But every one of them would be a felony at this point if this is passed.
That's correct. And so I guess when we think about, from our perspective in prosecution, when we think about laws and we think about how to prosecute cases, I mean, we always have to keep in mind what is the purpose of the statute. So when we're looking at damaging property in general, or we're looking at stealing property, things like that, those types of crimes are already covered under our criminal mischief statute. But when we think about legislation, and particularly when we think about legislation that's designed to deter bad behavior during crises like this, the reason that we kick it up to a felony is, number one, as a deterrent, and number two, as appropriate punishment. And we do this, and by the way, we do this with other crimes as well, right? So you can have crimes, but if you're going to use a deadly weapon during your crime, that's going to kick it up. If you're committing a crime, but you're already on felony release, that's going to kick up your punishment. So this type of legislation, we would always hope would have very few prosecutions under it, because we would hope that people would behave properly during an emergency, that they wouldn't divert very scarce resources that we have in the way of public safety and health, water, electricity, those resources, that they wouldn't be diverted because somebody decided to spray paint a government vehicle or worse. So that's why I think it's appropriate to have a more significant punishment, because the punishment is linked to the crime itself, of course, but also it recognizes that it's not just that individual crime of, tearing something down or destroying it. It has to do with when it's happening, because it's diverting resources that are much needed in other areas.
Right, thank you. Are you aware of this type of penalty imposed during emergencies in any other jurisdiction?
I'm not, actually. I have not done the research on that. I don't know that means that it isn't, but...
And can you talk to us about this particular emergency after the typhoon? Were there incidences of this? How many and what have you seen?
Yes, I mean, unfortunately, what our office has seen following the typhoon, and by the way, I should be clear that, again, as was sort of pointed out in the last presentation, sometimes things are still under investigation, and we will not, it won't come to my desk until somebody's actually been arrested. But for example, some of the cases that we've had have been people who are stealing electrical wire, things that were meant to go up to restore electricity to villages have been stolen. Vandalism, as the other senator pointed out, for water tanks. You know, those incidents are just devastating because you're talking about citizens who are living under such difficult circumstances. So for us to prosecute those crimes, we have to prosecute them just as regular criminal mischief, whether it's a felony or a misdemeanor, and we're limited. So if the criminal mischief, you know, is not really that substantial, we're limited. And same thing with the theft. So if it's not, you know, but what if somebody takes just enough wire that it really messes up the entire supply, but the amount that's at issue, you know, we're limited to them possibly just taking theft of public utilities, government property. So there are limitations. And I think the message that is sent when somebody is facing a felony for committing these types of crimes during a public emergency is, you know, how dare you? How dare you do that to your fellow citizens? So for that reason, I think we definitely support adding this enhancement.
All right, thank you very much.
Thank you.
Senator Taitakwi.
Thank you, Madam Speaker. Good afternoon.
Good afternoon.
Have you noticed any crimes, more crimes during an emergency declaration when the governor is called an emergency? Do you see crime increasing during that time?
We do. So we notice, in general, crimes of family violence. Family violence always goes through the roof whenever we have emergencies, whenever we have difficult times. Drug use goes up. Those are just in general that I've noticed, because we're also looking at all of the crimes that were committed during COVID. And as a result of, you know, some were violent, some were not violent. But when I'm looking back and looking at those to make sure that we're properly accounting for all of those crimes, family violence and drugs are really high on the list.
What about property?
Property
Theft of
damage
property.
as well. We do see property damage.
So a lot more than usual, even if from when we're in an emergency or when we're not in an emergency, you're seeing an increase to theft of property?
We see an increased theft of property, but what we also see is an increase in crimes of opportunity.
I'm sorry, say that again?
Crimes of opportunity.
Oh, crimes of opportunity.
So when we're in a state of emergency or we're in a state of crisis, you know, there's no electricity, so there's no alarm system. There's no, possibly no surveillance camera. Criminals know this. So they'll go after those things because they know that they can. And then when you have a typhoon that blows a door off or blows something out that allows easy entry, they'll take advantage of that as well. So we're seeing that as well.
Have you seen any other jurisdictions that have this particular proposed law?
You know, I have not done that research. I didn't do that research for today. It wouldn't surprise me if they do, because usually enhancements for different crimes are tied to all kinds of different things. If you use a weapon, or if it's a vulnerable victim, or if it's a government thing. So it wouldn't surprise me, but I just haven't done that research for today.
A felony, if I'm not mistaken, to determine whether it's a felony or not, are based on the value of a piece of property, when it comes to property, that is.
That's correct.
It's based on, what is the value amount for it to be a felony?
So for theft, it's based on misdemeanor, third degree second degree. So it goes zero, well, in petty misdemeanor, but anything below $500 is just a misdemeanor. 500 to 1,500 is a third degree felony. Above 1,500 is second degree.
1,500 is what?
Second degree, a second degree felony.
So the felony begins at 550.
It begins at 501 penny.
And 1 penny, right,
Yeah.
okay. And that's when a felony kicks in, regardless if it's that's today, right? Without
That's
an
correct.
emergency.
That's
Okay.
correct. And it's the same for criminal mischief, by the way. It's based on how much damage there is.
Okay.
So if it's something that's really insignificant damage, it's going
And-
to be misdemeanor criminal mischief. But if it just keeps going up.
And what is the penalty, other than, the definition of being a felony? But what can a person be put away for in jail? Is there a fine, or what happens?
There are jail, for all felonies and misdemeanors, jail, fines, community service. Those are all options.
Options, so there's nothing set in stone, like anything that's 550 plus 1 cent up to 1,000 is community service or anything. There's nothing in the books that basically gives the punishment, right?
Well, there is, because there's a determination as to whether you're a first-time offender. So if you don't have any prior felony convictions, you're looking at less jail time. If you do have felony convictions, then depending on what it is, there's a mandatory. So for example, if it's a second-degree felony and you're a felon, you'll definitely have like a minimum. I think it's 3 years. For the first-time person, it's 1 to 8. So there are some parameters that are put into place, but we don't have in Guam. We don't have sentencing guidelines, for example. Yeah.
So it's still left up to the judge?
It is.
Okay. Well, thank you so much for your time. I greatly appreciate you answering my questions for me.
Sure.
Thank you, Madam Speaker.
Thank you, Senator Taitagui. Senator Kanata.
Thank you, Chief Prosecutor Arizona. I really appreciate your time being here today, especially the testimony from Attorney General Douglas Moylan. We've certainly came to an unfortunate time. Instead of our people coming together in Inafa Maulik, we have a lot of individuals out there who continue to wreak havoc across our island, and for whatever reason. I think it also comes down to our upbringing in our own homes. I'm not too sure what the issue is with these people not putting their minds in the right place or in the state of mind, right? It's just very unfortunate and disappointing that we have to create legislation for these felonious crimes. Obviously, we already have our own situation with the Department of Corrections. We do not want to see more rampant imprisonment, but implementing such legislation like this, I applaud the author for the intent. I support the intent, but I'm not, we're going to be putting more people into prison for these things when they should just be doing right by the people and stop delaying further progress for our island. We obviously are dealing with a disaster, and these people are disasters themselves. It's quite idiotic that we have to implement legislation to deter this kind of situation. And I applaud you guys' work. It's a quite lengthy process, litigation. So I support this legislation, but I am also very much aware that Senator Barnett to my left has a huge situation with DOC. We've continuously heard numerous times that there's issues up there with retention and overcrowding. So again, I support this legislation, but it's just unfortunate that we have to implement legislation such as this to deal with idiots out there. It's beyond control. These people shouldn't be acting as they are today and impeding on progress for our island to be going back to its natural state. We already have enough out there, enough problems out there. These people should really put their heads together. And that's all I want to say. Thank you, Madam Speaker.
Thank you, Senator Kanata. Senator Lujan.
Thank you, Madam Speaker. Thank you for your testimony this afternoon. Let me ask you, to date, have the Attorney General's office received any complaints about public property destruction?
Yes.
You have?
We have theft. We definitely have theft. We have a couple of, I'd have to check back and see whether the dates of the destruction, but we do. And we
Okay.
have more now than we did
Okay.
3 months ago.
Okay, and those were in the executive and judicial and the different branches of government that you have received? Or are they
Pardon
mostly
me?
for the executive branch,
Um,
agencies?
Oh, the agencies? No, I mean, it's really, it's mostly agencies. Yeah.
Agencies, so
Yeah.
falling under the
Things
executive
like,
branch.
you know,
yeah,
electrical poles being damaged,
Yeah, okay.
things
Okay.
like that.
Yeah, no, because I mean, we've got a testimony here that takes no position because there have been no reported intentional vandalism or destruction to properties on the agencies listed. And that's why I'm asking if you had, because obviously they did not consult with you guys whether or not they've had, I mean, maybe not their particular agencies, but you have agencies that have reported in destruction or maybe intentional destruction or theft or
Yes, and I
Yes.
mean, I would also just like to be clear, I mean, I have to go back and look at when the dates are, but again, sometimes things happen and it won't come to our office until after someone's been arrested.
Okay.
So the police will be called, they're
Okay, yeah.
investigating, maybe they get a tip, maybe something happens, or also maybe they don't discover it until later.
yeah.
So there's that. I mean, if somebody just kind of comes in and spray paints something,
Sure.
you may or may not know
Sure.
who did it or when, and
Sure.
so there may not be a
Yeah.
call about it, but we certainly notice it. I
Yeah.
mean, I'm sure on Island as you're driving around, you can notice like,
Sure.
gee whiz, that seems to be vandalized, and
Yeah.
that wasn't like that before the typhoon. But maybe nobody knows who did it.
Sure.
So
No,
we
I
don't have a
understand.
report.
Yeah, yeah. And actually earlier you were asking about, about the, I guess, a definition that would be up to the legislature to maybe define the emergency. And I know we're not in that, what is it, condition of readiness 4 or 3,
Yeah.
whatever it may be. But I tell you, maybe this is something that we can consider, but it may, I don't know how long it's going to stick because maybe different administrations will have their own designations. Because to date, we are still receiving Joint Information Center recovery releases. And I think the last one we got was Joint Information Center release number 78. So we're still in that recovery mode, emergency recovery mode. So maybe, again, that'll be a part of a definition that, because we still, although we're not in that, that state, we are still receiving information regarding recovery efforts from the Joint Information Center regarding that. And so,
Right, and recovery takes a long time.
Sure.
So, and I was up in Saipan during Typhoon U2, and there's still buildings up in Saipan that have never, I think there's an entire school that was still in tents years later. So, I
Sure.
mean, it can take a really long time.
sure. Yeah, yeah, this could take a long time, so we can
Yeah.
still be receiving this the rest of the year. Something
That's
like
right.
that. But anyway, thank you very much.
Sure, thank you.
Thank you, Senator Lujan. Senator Brown.
Thank you very much, Madam Speaker. I did want to ask, would we determine that anything taken or any damage to public property would be considered a felony, no matter if the value is below $500? Would you
That's
still
right.
interpret it as that, so that if we pass this, certainly we're aware and the public's aware, that if they do any type of damage or take something, part of a generator, whatever the case may be, that would be considered a felony?
That's correct. I mean, I think my understanding is that's the intent of the bill, is to kick it up to a felony because of the crime being committed during an emergency.
I have no objections to the bill. I think it's unfortunate we have to send out a message like this. It's another reminder we're almost the land of the lawless because we have our own people, our own residents, that are unfortunately committing these crimes against their own neighbors. And that's not desirable, especially when there's such a need after a storm to recover and try to get back to as much normalcy as we possibly can in our community. It's just unfortunate. There was a time when we were here when we knew that if it wasn't yours, you don't touch it, or if you need it and it's something you really need, you ask permission. And If someone can provide it to you, they will, they will assist you. But this ongoing, crimes, and not just this against public property, but just, against the community of people just taking things that are not theirs and having no reservation whatsoever without it. It's unfortunate. I hope we get back to a better time. But thank you for coming down and providing your testimony. Thank you very much, Madam Speaker.
Thank you.
Thank you, Senator Brown. Senator Barnett.
Thank you, Madam Speaker. And thank you, Acting Chief Prosecutor, for your testimony. Yeah, I definitely get the intent of the bill, and I agree with the previous speakers that it is sad, for lack of a better term, that we have to introduce a measure like this to, serve as kind of a wake-up call. And since we hadn't had a storm in so long, I think we kind of forgot about how these desperate times just change people, really. But I do want to ask the Acting Chief Prosecutor, because I did get a text from a friend, is there anything in this bill that you think is not covered by crimes against the community, which is, I think, 9 GCA?
Yeah, the crimes against the community, it's not, you could still have this in addition to the crimes against the community. So this is sort of like an extra thing, sort of like the way that we can charge both family violence and aggravated assault or assault. And I would also say that, there are lots of areas in the criminal code that unfortunately we do have to have these wake-up calls. If you use a gun while you're committing a crime, that's an additional, it's an enhancement. If you commit a felony while you're on felony release, that's an enhancement. If you commit a crime against a vulnerable victim, that's an enhancement. So it's not, it is sad, of course it's sad, but at another level, when we deal with these emergencies, the idea is that they're really unique events, and people really should be doing whatever they can to behave properly and be helpful to the community rather than harming the community. Because all of these crimes that we're talking about, harming government property, the harm goes beyond what the fire truck is supposed to do. It affects the entire community, so it has a much wider ranging event. And I would say this, in response to the comment before about DOC, all of these crimes that we're talking about already can be punished under our criminal mischief statute, under theft, etc. So it's not like we're all of a sudden making a situation where there's going to be somebody going to DOC who would not otherwise have already gone to DOC. The question is, how long will they be at DOC, not if they're going to DOC. So I just want to allay any concern about that we're not generating more of a headache for DOC. But we do believe, regardless, that people who commit crime should be punished. And if their punishment involves jail time, they should go to DOC. I can't, from my perspective as someone who prosecutes crimes, that's not, I'm not going to not prosecute a crime because of a condition at DOC. I have to still prosecute the crime.
Yeah, please do. Keep prosecuting. It's okay. They'll figure it out. They'll figure it out.
We have to keep the community safe. So that's our focus. Yeah.
Yeah, and I mean, this is almost real time for me, this measure, because we were all there when I think it was the governor, lieutenant governor, come out with a video where they basically had said that someone had messed with one of the generators at the water well, and then there was an ensuing executive order, and use of water was then restricted, right? And I mean, it was interesting because the genesis of that was that someone had allegedly tampered with the well, and then there was a picture of somebody water blasting, right? And then it kind of snowballed into this, well, the executive order and all of the restrictions that I think Waterworks already, I think those might have been written down somewhere previously. But it's just interesting to me because you also had, as the chair of education, the schools were trying to repair and respond to the typhoon, but they weren't using water to flush areas like the bathrooms and everything because of the executive order, even though the executive order said that you could only use water for, I think it was like health, safety, and public welfare or something like that, right? Yeah, so I mean, I get the intent. It was funny, my daughter had even asked me if she was gonna get a ticket if she conditioned her hair, right, because of the, funny. So yeah, I get it, I support the bill, but I also get where you're coming from. And I'm just a little confused. We did get some testimony here from the Homeland Security Advisor, Esther Agagi, who says that she couldn't make it here, but she also further indicates in her written testimony, and I'm reading from this testimony, my office, quote, my office doesn't take a position on this proposed bill. To date, no executive departments or agencies, including the offices of Guam Homeland Security and Civil Defense, have reported intentional vandalism or destruction of their properties that may adversely impact operations and recovery, end quote. And so, did you, are you aware or privy to any reports of anything of this nature?
Yeah, so we do have in our office, and I've got to go back and look at the actual dates, but we do have reports of people damaging, in particular, I remember electrical poles. We do have reports of people stealing electrical wire. And actually, I'd like to respond to that comment because the issue is not, I mean, that would sort of elevate this into a situation where it might even be hard to prosecute, because if we're really going to link it to crime that's committed that then impairs recovery efforts, I'm not even sure how we define that impairs recovery efforts. Are we going to say that simply because somebody is going to have to take a vehicle out of commission for a half a day to fix something, is that enough to say that it impaired recovery efforts? What if it's only an hour or 15 minutes? What if the car needs some other, I mean, it's just, I think that that's not really workable, which is why I think that this bill, by simply saying if you commit these crimes during this time period, it's almost like a strict liability thing because it's tying it to the emergency. So, and I think you have to do it that way because otherwise, like I said, it's just going to be very difficult to figure out. I mean, if you have somebody who's intentionally breaking a lock that will lead to some place where water is stored, but the water isn't actually taken or impacted, do you then say, well, no harm, no foul, because, oh well. I think no, because police are still going to have to be called out to investigate that. They're still going to have to respond. Our office is still going to have to prosecute that case. And meanwhile, the police could have been doing something else during the emergency. So that's kind of the I would imagine, the thought behind this kind of a bill, is to say, during times of crisis, we need to make sure that all of our resources are used best for the recovery, for protection of human life, number one, but then for recovery. And so if they're diverted for that because somebody decides to commit a criminal act, that person needs to be punished because they've not only committed that crime, but they've also diverted these very limited resources in a time of crisis.
Yeah, and I mean, again, I totally support the intent of the bill, but you know, this would ring a whole lot truer maybe a month ago, right? But now that we're like 99%, let's just throw out a theoretical. So now we're something like 99%, and I deeply apologize to the 1% out there who don't have power because they feel that every time we say 99. Well, let's say someone was to go out there now and take some copper wire off a GPA truck. In your opinion, would that be something that, you know, we can charge them with a felony for?
I mean, under this law, I would think so if it were revised and redrafted in the way that we're suggesting, because 99% of people may have power, but you know, power is still very important to that 1%. And I don't think that anyone should sit back and rest until everybody has that power, everybody has that water, because that's what's required in the community. And the people who are not, enjoying the benefit of electricity or water, they are really suffering. And the people who even now have electricity and water, they're still suffering because their homes have been destroyed. They've lost, all their photographs during the typhoon. They're still suffering. But for the 1% who do not have water or power or don't have one or the other, I mean, it's a tragedy, especially at this late date following the typhoon. So yes, I do think that if somebody were to take copper wire now, and we have had reports of wire being stolen, I think they should be prosecuted, and I think that they deserve to have a special penalty because we're not 100%, we're not where we were. We are still feeling the effects of the typhoon. And it's not fair to the community to have the community bear the brunt of that. So our office is limited to charging things as they are, but I think a special enhancement for time of emergency is very valid.
Could you, if you don't mind, ma'am, could you just expand a little bit on the point, because you had said in your testimony that you would have liked to see, or you would like to see this extended to 90 days past an emergency declaration?
Right, past the declaration that the emergency has ended. So the reason for that, and again, I always have the example of Typhoon U2 up in Saipan, because even though the emergency was over, electricity was restored, water was restored, for quite some time after, we still had to deal with the after effect. So simply because the emergency is technically over, the emergency, it doesn't mean that the infrastructure is 100% back. It doesn't mean that there aren't still repairs that need to be made to restore things to the way that they had been previously. Because a lot of times, agencies are working very difficult and diligently to just get the power turned back on. So they're doing a fix, whatever they can do at that time, but they know, because they've got this village, that village, the other village to get to, they know they're gonna have to come back, because they may notice things. Oh, that still needs to be replaced. It will work for now, but the typhoon really destroyed it. We're gonna have to come back and redo that. So for that reason, we believe that extending that time period is important because, first of all, the way that the bill is actually drafted, it makes it very confusing when it says times of public emergencies. When I read that, I'm not sure if that means just during the actual typhoon itself. I'm not sure what that means or the time period. So that's why I think it's very helpful to have an actual date, a date certain, so to speak, because I think that that's fair within 90 days following the end of the emergency. If you continue to do things to destroy property, to take property, to do different things, then you should still be held accountable, because even after the emergency ends, there's still going to be efforts required to fix things, as we see. So.
Thank you, ma'am. No further questions. Thank you, Madam Speaker.
Thank you, Senator Barnett. Senator Taitsquiki had another question.
Thank you, Madam Speaker, for obliging me. I had the opportunity to look at Title IV, Chapter 9, in which the legislation is proposed to be placed into the Guam Code Annotated, and that is right below where it says destruction of property and penalty. The bill talks about destruction of property, but I've heard that there's been property such as generators or certain properties that were stolen. So what's the difference between the definition here on destruction of property, which the bill clearly says destruction of property, versus if someone just comes in and steals a generator?
Right, and that's actually, well, there is a big difference. But that's why that is our proposal, actually. We'd like to see it be a more robust bill and actually include government property that's misappropriated, misused, or even, which would include kind of taking things. As well as, I mean, the legislature could also consider just crimes in general that are committed during times of emergencies, whether there should be a special allegation such as this to kick up the penalty or impose an additional penalty for any crime, really, that's committed during a public emergency. So yeah, I mean, the bill does speak of that, and that's why we've suggested that actually it be increased a little bit, the scope, because during times of emergency, it's not just things that are damaged or destroyed, it's also things that are taken. I mean, you could have a generator that's designed to keep an agency office partially or totally with electricity for the agency to operate. And if you have an agency employee who decides to take that generator home to just use it at his or her own house, I would think that during a time of an emergency, you'd want to penalize that person, not just for the theft and for the official misconduct, but also just because it's during a time of an emergency. And again, it's harming the community by impeding an agency's ability to function during that time.
Okay, so that being said, do you think that the area in which this bill is located in this particular chapter and title is in the right area?
Well, I leave it to the legislature. I certainly think that it would be better to have something like this under Title IX, probably under Chapter 80, dealing with, well, I mean, it depends on what the legislature wants to do. If it wants to kind of have it as a special allegation type of thing, the way that we do already for people committing felonies while they're on felony release, or if the legislature wants to have a totally separate crime, which could then be very specific as to the type of emergency and the time frame, et cetera.
Okay. I don't know if this was asked already, Madam Speaker, with regards to the type of degree of felony, because if it's not mentioned here, I don't know if Senator Barnett brought this up about the type of degree, whether it's a third degree, first degree, second degree. Without it being mentioned in here, is it automatically a third degree?
I don't think it would be. I think it would need to be tied. It would need to specify which kind. It could also specify, for example, the specific punishment, but it should specify the type of felony, and it should specify which
And the bill doesn't do
jail
that.
sentence that would be added, et cetera. I mean, they're just, some things maybe more specific, yeah.
Okay, thank you. And thank you again, Madam Speaker, for the opportunity.
Thank you, Senator Taitigui. I hear what you're saying about all crimes. I know there's people in the community who might resonate with that because, for example, we've got our houses open because there's no aircon, there's no power. We've got generators outside, and then when those get stolen, or I've heard people who've had that experience on top of everything else they're going through, then their stuff gets stolen in the middle of no power situations. It's really, they are really angry about that, and of course, very much more, traumatized, I think. But thank you for your testimony today. The sponsor, you may close or conclude.
Thank you, Madam Speaker. I introduced this bill with a very heavy heart. This is not a piece of legislation I am particularly proud of. It breaks my heart that it has to be introduced. As far as the comments from Homeland Security, I do want to put an emphasis that a majority of the vandalism was done to GPA and GWA autonomous agencies. And that as somebody who believes in the power of forgiveness and second chances, just recently we even passed a bill allowing felons to avail of themselves of SNAP and, go on the road to recovery. We had many people ask the question, what kind of message are we sending to the community? So I hope that with this law, we send a clear message to the community that in times of emergency, this mischief will not be tolerated. I worked many years as a frontline worker during emergencies, and it would have been disastrous to be an emergency worker and have critical equipment fail when you didn't need it to be failing. And I don't ever want to get to that position. So we will nip this in the bud. And I would like to thank you for your suggestions. As far as I'm concerned, this is a tool for your office to help clean up our streets, especially if they're doing it during these times, because honestly, shame on them, and they should know better, the people that would do this to their community. So I want to make sure you guys have the tools to do that, and your recommendations will be duly noted. And with that, I yield the rest of my time, Madam Speaker. Thank you.
Thank you, Senator Parkinson. And again, thank you, Attorney General's Office, for testimony today. The public hearing on Bill number 132-37 COR is now concluded. It is about 3:43 p.m. Si Diyos masi.